Okay, well, like I said, I don't want to waste anybody's time, especially those that showed up on time here. So we'll get started and hopefully people can trickle in and join us in a little bit. So welcome to everybody to the Collmer and Wilson Group's workshop series. For those of you who have not met Ronni or myself, I'm Jeff Wilson, broker associate with Keller Williams Realty, and say hi, Ronni.
Hello, I'm Ronni Collmer, broker associate with Keller Williams.
All right, and we wanted to say hello to our past and present clients who are sitting in with us today. It's great to see you, and as always. And there are many of you in here that Ronni and I have not had the pleasure of working with. So we would like to say hello and welcome to our future clients. Again, thank you all for being here, and we hope you are enlightened by this presentation. Before I introduce Joel, just want to click here. We would love to see everyone's face, but we understand if you do not want to turn on your video, so don't worry there. Please keep yourselves muted during the presentation. There will be time at the end to unmute and have a discussion. Please feel free to type questions into the chat. We will keep track of all the questions and we will pose them to Joel at the end of the meeting. If there is anything pressing about what Joel's talking about right then and there, or some clarification that's needed, definitely post that in there and Ronni will interrupt Joel and get that situated for you. All right, and without much further ado, it is my pleasure to introduce you all to Joel Harris, attorney at Joel Harris Law Offices with offices in Clayton, Antioch, and Walnut Creek. Joel has been practicing estate law for over 30 years and is a state bar board certified specialist, I can't speak tonight, in estate planning, trust, and probate law. He is a perennial California super lawyer and a really nice guy with great Giants season tickets. Ladies and gentlemen, Joel Harris.
All right, here we go. I was told I couldn't talk too long to make room for questions, but what I decided would be best to do, we're focusing on how to protect your home and in some respects other assets from all kinds of dangers out there. And I'm going to pretty much use a story to illustrate each one of these. So we're going to start with how to keep your house out of court, because that's what a lot of people come and see me for, but a lot of people do it the wrong way. So there are good ways and bad ways to protect yourself from court. And the most common and perhaps the worst way is joint tenancy. A lot of folks use it. Title companies often recommend it. Or you just get it by default because when you go in to buy a house, a title company tells you to your eyes and throw a dart at deciding how to pick which form of title. But the good thing about joint tenancy is when one joint tenant dies, the other joint tenants own it, whether you like it or not. The problem is a lot of husbands and wives use joint tenancy as their estate plan. And then when the surviving spouse dies, the family is shocked to hear they have to go through probate because joint tenancy only takes care of the first spouse. But today I was meeting with a realtor when I was talking about, the blind leading the blind when it was coming to title. And I told them, wow, you're a realtor and you have joint tenancy with your husband. Didn't anyone ever tell you about CPRWOS? And she said, what is that? And I said, that's community property with right of survivorship. So for husband and wife, it's the same as joint tenancy without any of the downsides of joint tenancy. So it gives us husband and wife the right to inherit from each other. But one of the big traps with joint tenancy is that can create a tax that community property doesn't. Now, of course, this is just for husband and wife. So here's a story. I had a lady come into my office. She had a house and 2 rentals. And she and her husband decided that they just needed joint tenancy. And when one of them died, the survivor could then set up their estate plan. So she came in and told me, her properties, here are the deeds, they're in joint tenancy. I just want to get my properties and set up a trust. And I said, well, I recommend you go to probate instead. And she thought I was crazy until I explained that with joint tenancy, you get a 50% step up in basis when you inherit from your spouse. And with community property, whether it's through right of survivorship or through a living trust, you get 100% step up in basis when your spouse dies. Which means if you get 100% step up, number one, if you want to sell a property, you can sell it with no capital gains tax. Or if you want to just keep that rental, you can start depreciating it as if you just bought it, and that gives you a huge tax deduction. So joint tenancy is a good way and the worst way to avoid probate on the house. If you're married and you don't have a trust, community property with right of survivorship is the way to go, assuming it's a community property house. But we have a new law in California. So I had somebody shocked on Monday when I told her that she doesn't need a living trust, even though she has a house and wants to make sure her son doesn't want to go to court. I said, all you need is the new California revocable transfer on death deed, and we can just update your deed and put your son's name as a beneficiary on the house. He's not an owner until you die. And then when you die, we file the death certificate with the county and voila, now it's his house, no probate. I've been using these deeds more and more often, but they're only really good in limited circumstances. So I had someone else today who they have 3 kids and they don't get along. So I told them it would be a terrible idea to put them all in the deed together, because then no one's in charge and they'll just fight about it and end up in court. So if you have multiple beneficiaries or children or special needs beneficiaries, this won't work. But if you're leaving your house one person, that may be all you need to do, is a revocable transfer on death deed, no court. And of course, the classic way of avoiding probate court is a living trust. There are many reasons why you want a living trust, and Alameda County Court is one of them. Alameda County Court, if we were to ask for a court date today to start a probate, they will give us a date in July or August of 2023. That's just to start. So I'm telling people you're going to wait 4 years if you're going into probate in Alameda County, because there's such a long wait. A living trust avoids the time delays, expenses, and a lot of other issues. But those are your 4 ways to keep your house out of court. Unless there's any burning questions, Jeff, I'm going to move to the next screen.
All right.
Which means you do it.
There's no questions.
Any question I should do right now, Ronnie?
There's no questions
Oh,
right
okay.
now.
So let's talk about protecting your house from taxes. And the main thing I want to touch upon is Prop 13 and Prop 19. So once upon a time in California, we had this lovely law that said that not only could the counties not go crazy on your property taxes, but when you died, you could leave your house and a little other property to your kids without being reassessed. And if your kids died, you could leave it to your grandkids and they wouldn't be reassessed. But the voters, in their infinite ignorance and not understanding what they were voting for, voted for Prop 19 and eliminated the transfer on death and keep your property taxes, with one small exception. There will hopefully be a bill on the ballot in November to reverse the bad parts of Prop 19. But if you were planning on your kids or grandkids being able to inherit all of your properties and pay your low taxes, that's not going to happen anymore. So how do we protect from that? Well, there were some planning options available before it went into effect. Now the best thing we can do is vote for the Repeal the Death Tax Act in November. To protect your properties from capital gains taxes, I recommend dying. Now, I usually don't recommend dying, but what I mean by that is don't put people on the deeds to your properties. So a big mistake a lot of people make is they give away their properties early or put their kids or grandkids on title, and all kinds of problems can happen. But the one I'm going to focus on here is that they won't get a step up in basis when you die. Typically, when you die with a will, with a trust, with nothing, all of your assets get a step up in basis and can be sold free of capital gains taxes, but not if you put their names on it before you die. So it's better to inherit than to get a gift of highly appreciated assets. This counts for things like stocks and bonds too. There are also a lot of ways to protect your estate from estate taxes. The good news is right now you can have $12 million as an individual or $24 million as a couple, and there's no inheritance tax. That's set to drop by 50% on the last minute of 2025. And if the law doesn't change until then, families with larger portfolios will make very large gifts around Thanksgiving of 2025. But you need to pay attention to what happens with the tax laws, because President Biden tried to drop the tax exemption to 3.5 million, which currently gets you a 4-bedroom house in Walnut Creek. So because of property prices being what they are, we need to do some extra estate planning if your estate goes over the tax limits. We can do gift planning. A lot of people used to buy estate tax insurance, a life insurance policy that could be set up tax-free to pay off any taxes. So right now, a lot of folks aren't worried about estate taxes, but they are looming, and we're going to get a huge deduction sometime between now and the end of 2025. Next.
All right.
All right, no questions.
All right, that means I'm doing a great job.
I'm sure you are. I'm taking notes.
So this one hasn't come up since yesterday. I get a lot of people concerned about the cost of nursing homes and long-term care, and how they qualify, and then what happens to their house when they die. So first of all, one secret that a lot of people don't know is when you are applying for long-term care benefits from the state, they don't count your house, your primary residence, as an asset. So that counts as zero. So a lot of people can qualify and they don't realize it. And it doesn't matter if your house is worth 3.5 million or 350,000, which would probably put it in Idaho. So your house is a protected asset from qualifying for Medi-Cal, but your house is not necessarily a protected asset when you die. So what a lot of folks do know is that Medi-Cal will put a lien on your house when you die, and your family will have to sell the house and pay them back for all the benefits you receive, which is currently over $10,000 a month for a nursing home, plus any extras and medical that you received. But a few years ago, the governor of California signed a wonderful and miraculous bill that says that Medi-Cal liens can only be enforced against homes that go through probate.
Oh.
So one more good reason to have joint tenancy, community property with right of survivorship, a transfer on death deed, or a living trust, because all of those eliminate the need to go through probate, and will eliminate the Medi-Cal liens, which can take away the entire home. I've had cases where I had one recently where the family it was kind of distant family. They didn't know that grandma was on Medi-Cal. And when she died, they went through the process, sold the home, and then Medi-Cal sued them for all the money, 100%, because she ran up a big lien. And in those days, they could go after the home no matter what. Now, when we go through probate, we are required to give notice to the California Department of Health Services and say, hey, we might have a Medi-Cal recipient. How much do we owe you? So we can pay them back before your family gets anything. So don't go through probate. Probate takes years and costs a pile of money, which I don't mind because I'm the lawyer and I get half the pile and share it with the executor, but it's not good for your family.
Yeah.
All right, Jeff, next screen.
All right.
Any questions, Ronni?
No questions.
All right, we're going to finish up in 10 minutes. The next thing you want to make sure is you protect your home from lawsuits and creditors. I had a call last week from a client who's being sued and said, all right, what can I do to shelter my assets now? And the answer is too late. It's considered a fraudulent transfer. Once you're sued, a lot of the strategies won't work. So I asked him if he had insurance, and he said, well, yeah, I'm an insurance agent, but I didn't think it ever happened to me. So I just did this and told him, so not only do we want to have homeowners insurance, but the key component here is the liability policy, which protects you from all the crazy lawsuits you hear about, some of which are true. Someone breaks into your house to steal from you, or they're partying in your house when you're not home and they hurt themselves and sue you. That happens. Pardon me, I have to drink, but it's just water. I can show the bottle. But the thing is the other thing about homeowners and liability insurance is, and perhaps the most important part, is the free lawyer. So they pay for your defense. And for a lot of these crazy cases, that's the only expense you'll ever have. But for the client I was talking to last week, those lawyer fees were getting him to want to ask me bankruptcy questions and hiding asset questions. An umbrella policy, hopefully you all have one of those, is a policy. They usually go by the even millions. So the cheapest and easiest is a $1 million policy, and that will cover your home, your cars, and if you have a second home, that can cover that. So for a couple $100 a year, you get a backup million, or you can get 2, 3, whatever you want. And that's a great way to protect your assets. So, a lot of people say, well, let's put them in a corporation that we have our, secret children hiding in the Cayman Islands. And that costs a lot more and works not as well as paying a couple $100 a year for an umbrella policy. So insurance is one of your best protections. So today, let's pick on that realtor I met with again today. She was all excited about her trust because now she said, if someone sues me, they can't get my assets, right? And for revocable normal living trusts, no, that's not right. Your assets are still yours. You can take them out. You can do whatever you want with them. So they're still responsible for your debts. However, they are not responsible for the debts of your heirs. So when people die and the family comes to see me, I ask if there's any reason why someone might lose what they get. And last month they said, well, 3 of the 4 of us are in bankruptcy. But and I've had, people in jail, a lot of divorces lately, people getting sued, so the trust can hold back their assets and protect it from their creditors. It can protect it 100% from pretty much anything but bankruptcy, and 75% of their share from bankruptcy. So, and it certainly can protect it from their spouses because inheritances are separate property. So a trust does offer asset protection from creditors for everyone but the creator of the trust, unless it's an irrevocable trust. So if you create an irrevocable trust when you're not being sued and someone sues you later, they can't touch the assets in your trust. Irrevocable trusts are set up for normally tax protection, but they also give you creditor shelters as well. I did a lot of irrevocable trusts last year because they protected people from reassessment on their homes when they were being transferred to their kids after Prop 19 went into effect. My clients were all between San Francisco and San Jose, and all of their properties would have significant tax increases if we didn't put them into an irrevocable trust. It is too late to use an irrevocable trust for Prop 13 planning now because Prop 19 is in effect. There are other fancy ways to protect your assets from creditors as well, but they don't always work for real estate. So a lot of folks have read John Grisham novels. I'm a big fan because a lot of what he says is true. You might recall in the movie, I believe it was The Firm, there were clandestine trips to the Cayman Islands. And the reason they were doing that is the Cayman Islands and some of these other, what they call island strongholds, they do not recognize judgments from out of their little countries. So if people sue you and they bring the judgment to the Cayman Islands, they won't give them any money. But that doesn't help you with your house very much because it's hard to dig it up and take it to the Caymans. All right, next screen.
All right.
Now, so I'm done with how to protect your home. So a couple of tips. Don't be a procrastinator. Last January, I had 3 clients die who all had unsigned living trusts sitting at home. 2, 3, and 4 years is how long they had them. And they never signed them. And I got 3 nice sparkling new probate cases, which are still going on. So have some sort of plan, especially if you like your heirs. And if you decide you want to have a plan, I don't recommend trying it at home. You've heard that on TV. Today I had somebody come in and the entire estate plan was an online power of attorney they found and filled out, and the form is no longer valid in California. It was eliminated about 10 years ago. So that means they had nothing. Plus the form, when it was valid, expired on death, so they still would have had nothing. That's where all the big juiciest probates come from, is the do-it-yourselfers. I've yet to see anybody do it right, but I've only been doing this 32 years, so maybe someday I'll see it right. When it's time to review, when the family comes in to sit down with me to go over the will or the trust, I always start with the asset schedule. Trust is supposed to have an asset schedule with the trust. So we pull out the asset schedule, we dust it off and look at the faded print and find out that nobody had ever changed it since it was signed in 1983. So it's really hard for your family to know what's going on if you don't make things, bring it up to date. When I was a baby lawyer, I looked even younger than Jeff Wilson, but had way more hair. I did my very first, what we used to call a will reading. So the family brought in the will and wanted me to explain it to them. And as we read through it, we figured out that every single person named in the will was dead. Obviously, it didn't work. So ladies and gentlemen, boys and girls, you cannot write a will and put it in a safe deposit box and assume it will magically update when your life changes. So when you get married, divorced, have children, sell children, win the lottery, whatever happens in your life, you have to update your estate plan. And your estate plan needs to be flexible. So I was meeting with folks today and they have one grandchild. They're hoping for more. And they wanted to say that, we want to leave some money to our grandchild. And I said, well, why don't you say you leave, $10,000 to each grandchild? And they said, no, we only have one, we want to name him. And I said, well, if you do that and you have another grandchild, you have to update your plan or they're out. Oh, so it's best to say each grandchild. Set it up so that you're less likely to fail. We always want to put backup beneficiaries in your documents so they're less likely to fail. Jeff, I'm working on a blog right now with our friend Adam. And what it's all about is funding your trust. So a lot of people set up their living trust. It's like a bottle full of water and they don't put any water in it. Or if they do it, initially they spend the rest of their lives pouring it out or drinking it. So when the families come to me with a living trust and the folks have died, the first thing we do is try to figure out what's still in the trust. And it's very rare in my experience to have a trust that's full. Usually it's like my water bottle, it's full up part way and the rest is empty. So now what happens to the assets that aren't in the trust? Well, first of all, probate. Second, we don't follow the trust's directions, we follow giving things to next of kin. So I was telling a family today with a blended family, if they didn't set things up right and they don't do, leave things out of the trust or don't have a trust, that one spouse's kids potentially will get everything and the other spouse's kids will get nothing. So you need to fund your trust. Now, saying that doesn't make it happen. Listing it in the trust doesn't make it happen. You actually have to go to the bank, have a new deed done for your property and so forth. So what happens if you do leave things out? Because my 90-year-old clients are basically, old folks gone wild. If they see an interest rate 0.01% higher, they're going to another bank and they do not remember they have a trust. So whenever you have a living trust, you're always supposed to have a backup will that says, I hereby leave all of my assets to my trust. So that way, at least they'll get in the trust and be distributed the right way. Number 5, make sure you plan for yourself too. A lot of folks, okay, we want a will. We want to make sure the right people get things when we die, but a will only works when you're dead, and that's no fun. What happens if you get sick and we need to take care of you? So the biggest problem I had during COVID is I had hundreds of calls of people stuck in care facilities, hospitals, nursing homes, who never got power of attorney, and now nobody could pay their bills or help with medical decisions. And so they were all calling me, and there's nothing I can do because they wouldn't let me in, with an exception of the orneriest client I ever met who actually bullied his nursing home in Concord into wheeling him outside and setting up a desk and table for me so I could sign his powers of attorney in my hazmat suit during the height of COVID. But that's the only one I was able to do. And I'm not going in a hospital. Don't go in hospitals these days. It's always a bad idea to surround yourself with sick people, but now more than ever, you want to avoid those places if you can. So folks, have a plan, keep it up to date, make sure it's set up correctly, and then you'll be taking care of yourself, you'll protect things for yourself, and you'll have taken care of your family. So that's kind of some 101 estate planning tips. Next screen.
There are still no
Ta-da.
questions.
All right, so now it's called the audience participation part. So let's turn off the mute. You don't have to type in questions. You're welcome to ask me questions. If not, I'm going to go get something stronger to drink and call it a night.
Anybody
Linda
have any
Worth?
questions?
Actually, I have a question. I must have missed something. When it says fund your trust, meaning we need special bank accounts for it, or just attach the bank accounts to the trust?
Attaching the bank accounts to the trust does not accomplish it. You have to go into the bank and say, hi, I have a trust. Here it is, or here's the summary version. Please put the name of my trust on my accounts.
Okay,
And then
Got
your
it.
bank statements will say the name of your trust on them, or they'll put trustee after your name. If it doesn't say that, they're not in the trust.
thank you.
Now, the probate rules, we've got a bigger threshold now. It used to be when I was starting off, if the accounts or your estate was over $60,000, it had to go to probate. It went up just in April to $180,000 of non-real estate assets, or $60,000 in real estate. Find that in California, I dare you. If it's over that amount, then it's a full probate
Wow,
for 180,000 or more.
that's amazing. I have a question. So in regards to irrevocable trusts versus revocable trusts, there's a lot of benefits, it seems, to irrevocable trusts. Now, I assume that not everybody chooses irrevocable trust because you can't play around with the trust after it's created, correct? Like you can't move things in and out and do all that.
Irrevocable, Robin Williams would have called that a vowel movement, ladies and gentlemen.
Yeah.
So an irrevocable trust can protect your assets from creditors, can eliminate inheritance taxes, can protect things from being reassessed, can give you control from beyond the grave, but they have one big downside, and that is you have to give your stuff away. The minute you sign that trust, whatever you put in it isn't yours anymore. And sometimes that's bad. So for most living trusts, we don't want them irrevocable, but sometimes we do. So let me give you the best example. I put life insurance policies into an irrevocable trust for people. And especially insurance policies that are for like your kids or grandkids, because insurance is part of your taxable estate. But if you put the policy into irrevocable trust, it's not yours anymore. So it's protected from your creditors, and we can eliminate taxes, and you can make sure the grandkids can't blow the money till they're 45.
Nice. All right.
Hey, Cindy, you've got a better background now.
I'm Michelle here. She wants to talk to you. Hi, Joel.
Hi, Michelle.
Hi,
Hi.
Jeff.
Hey, I had a question. You had mentioned in regards to like for a property, I know payable upon death or updating the deed, so there's a beneficiary to it. Is that different from a tax perspective later though, for the beneficiary?
No.
So they're not going to be taxed on it or anything.
Oh, no, so whether you put the property into a living trust or put a beneficiary on it, it's the tax situation is not affected. So
Okay.
if you're over $12 million, there's still going to be a little
Yeah.
tax, because it's not a gift while you're alive. It's like putting a beneficiary on a life insurance policy or bank account.
Okay.
When you die, they get it, but when you're alive, it's yours.
Okay. Perfect. Thank
Good
you.
question. So in California now, almost any asset you have can be made into a baby trust by putting a beneficiary on it. So bank accounts, brokerage accounts owning stocks, bonds, and mutual funds, annuities, IRAs, life insurance, and houses now can all have pay on death on them, and that avoids probate. which is great. Just make sure you have the right beneficiary. I teach a class on naming beneficiaries. So you can't put a baby or someone in jail or an incompetent person, or you don't want your ex on there, or, you know, other strange things. So you
Yeah.
got to make sure you got the right beneficiary on.
Okay.
Now, what if you consider somebody incompetent, but the rest of the world might not?
Then you definitely don't want to put them on there
Yeah.
because you're in charge. It's your house.
All right. Any other questions? These are good questions.
Um,
You've got a lawyer in front of you. It's a good time to ask questions, right?
Actually, I have a question. If you make your trust and you have items like that are on a gift list, because it doesn't, from my understanding, it doesn't go into the body of the trust. There's a list of you want person to get this or a person to get that, maybe a little money or jewelry or something, or a car. It goes on a list that's attached to the trust. Is that correct?
Well, it depends on the trust. So a lot of trusts, including mine, will say inside the trust, in the distribution, that any special gifts on exhibit whatever are distributed first. And then there has to be a signed and dated exhibit attached to the trust. And then if you want to change little gifts, that's all you have to do is sign and date a new one. You don't have to redo the trust.
So that's like the attached list.
Yeah.
Okay, to change it. Does the assigned list have to be witnessed and notarized to be a legitimate part of the trust?
Nothing in estate planning needs to be witnessed except for a will or a medical power of attorney, which you can either witness or notarize. But when I have people do those gift lists and they make large gifts or real estate gifts, I have them notarized. If they're just making small gifts of personal things, then I don't. But they still need to be signed and dated.
Signed and dated by the person making the trust.
Correct. It can't just be a random list that someone typed up and claiming is the gift list.
So what would make a list not valid?
So, well, if it wasn't signed or dated, if it's not signed by the person making the list, then it would be easily challenged. Or if there are mistakes on the list. So for example, or things that are illegal. So I've had people make gifts of assets. So let's say, you know, I give Johnny my Wells Fargo account, and when they die, their money's all at Citibank. Or I had a lady put in, I give my house to my son, but only if he divorces his wife, and that's illegal. So I like to review these gift lists for people when they update them, and I always do the initial gift list. But most of the time, the gift lists work very well.
Okay, so who signs the list? The trustee?
No, the creator of the trust.
I'm sorry, that's what I meant.
Yeah.
Okay, and if they don't sign it, but it's witnessed, then it's not valid?
No, because you don't, witnessing isn't for trust, that's notarizing.
Oh, okay, so
The notary, and you can't witness a signature that doesn't exist.
okay, so if you have 5 children and there's a list for every child, if the trust maker does not sign each list, it is not valid. Is that correct?
So it would, yeah, I would agree that it would be not valid.
Okay, thank you.
So that, unless the family agrees, when folks die and the family and the heirs all agree, they can do anything they want, even change everything in the trust. But my experience has been often the opposite, where nobody agrees. So if we have these random lists that aren't signed and there's no way to prove that somebody did them, then how does that, you know, survive a challenge?
Okay, if it's an as per attached of money to be given back, if it's an as per attached, if that's just also signed by those who make the trust, it's okay. But if it's money like that needs to be paid back, if it's does need to be notarized?
It should at least be signed, but notary always makes it better because that's proof that it was that person's signature.
Okay, thank you.
I've seen so many fake trust amendments in my day that I now, in my trust, require an amendment to be notarized to be valid.
Okay.
And you are a notary, so you could easily do that.
Right. I'm a notary and I have 2 more notaries in my office. So for my clients, it's easy and they get lifetime free notary.
All right. Any other questions?
I have a question.
Yes.
You just talked about Medi-Cal concerning nursing homes. I thought Medi-Cal was just for really, really low income people. What if you're in a nursing home and you don't have Medi-Cal?
Yeah,
They still-
well, there are two tests for Medi-Cal. First, you have to qualify financially, and a number of assets don't count. They count as zero. Your house is zero.
Oh, good.
Your IRAs and 401ks are zero. Normal personal property and a vehicle are zero. And then in addition to that, if you're married, you can have about $125,000 in cash or anything else.
So what does count?
So cash and investments over the 125,000 or additional properties.
So
if
they
you have-
so
if
they
you have-
take your Social Security check and your,
Well, no, we're just,
Or what?
that's not an asset.
that's not an
So
asset.
that doesn't count for the asset test. So to qualify, you have to be under, and there's a great website that tells you all about this and keeps it up to date. It's called canhr.org. Put that in the chat, Jeff.
Put that in because I don't have anything
Got
like
it
that.
right now.
Canhr.org. It stands for California Associates for Nursing Home Reform. Canhr tells you all about how to qualify for Medi-Cal, and there are ways you can shift assets around. There are ways you can take regular money and turn them into a retirement account. You can fix up your house, pay down your mortgage. You can even make a limited amount of gifts and qualify. But that's only to qualify. Now, to actually get benefits, there's also an income test. So they'll only pay $10,000 a month for your care, and you're going to have a copay. If you are single, your copay is everything you make per month minus $35. You get $35 mad money, and they take the rest, but then they pay. So if you're making $4,000 a month, they'll pay $6,000. If you're married, you get to keep about $3,000.
I'm single. I'm single. I have
Yeah.
nothing. No,
Yeah, so if you're single, you only get
no
to keep
dependents, no
35
nothing,
bucks.
just me.
If you're married, you get to keep a lot more income.
Well, 3,000 versus $35 is huge difference.
Right.
Did I understand that right?
Yeah, because if you're married, the person with a healthy spouse living at home needs money to live off of.
Oh, I
So
see.
you can
There's,
ask for money for your regular, you can get your minimum amount, 3,000 something, plus there are other things you can keep additional income for. And then anything over that becomes a copay. For most people, that still beats paying at least $10,000 a month. Because if Medi-Cal pays $10,000 a month, you're not going to get a nice private pay situation for less. It's going to be more. So you're going to, you want to go over to Rossmore, you're going to pay how much, Linda Worth? What's the rate today?
It just depends on what you're, living in.
Yeah, skilled nursing home in the Rossmore area.
Or in the Rossmore area, it could be as high as 20,000 a month.
Yeah, and you can't touch it for 10 because anyone can get them for 10. So those are all sold out, right?
Yeah.
Yeah. So that's why folks get long-term care insurance, by the way. That's another good way to protect your assets.
A little
But,
too late for me to do that now.
Yeah, once you're sick, it's too late. It's you. The younger you are, the better you are. But you can get different kinds now. You can get them combined with life insurance, and those are nice too. Okay, next question. I did Medi-Cal Planning 101. I did 2 semesters of a class in 10 minutes.
There's no questions in the chat. Anybody?
no, it says, yep.
All right, so I'm going to put my information here.
I already have it. I already have it on the
right.
last slide. So
Perfect. So put it on the last slide. We want the next slide.
So before that, I want to talk about our next workshop. It's going to be, so you can mark your calendars. It's 6/23 at 6 p.m. Our speaker will be Ben Bauer with Delta Lending Group. He's not just going to talk about loans. He is a wealth of knowledge with regards to macroeconomics, what's going on in the government, the stock market, what's going on around the world internationally, and how that affects us and our money. So he's a really great guy to have speak, and I'm super excited to have him. So that's coming up. And then here is our contact info. I want, while you're writing stuff down, I want to make sure that we thank Joel Harris for being here. He is also a wealth of knowledge. Obviously, he knows what he's talking about. He's been doing this for a very long time, and we love referring our clients to him, and they are always very happy with his service. So if you do have anybody that's interested, has any questions whatsoever with regards to estate planning, Joel Harris is your guy. So thank you very much, Joel. We really appreciated having you, and thank you all for being here. We really appreciate you, and please let us know if you have any questions with regards to real estate or estate planning.
So Joel Harris added joelharris@aol.com.
Sorry.
Oh, you have my fancy work email address, and it hasn't been behaving itself. I think it has COVID. So to get through to me better, use my home email address.
All right. So yeah, joelharris@aol.com is what he posted in the chat.
Yep. And I'm happy to review and update and fix old estate plans, do new estate plans, and help you when you're dead, but no hurry there.